A Louisiana statute required railroad companies carrying passengers within the state to provide, quote, equal but separate, unquote, accommodations for white and black persons. It empowered train officials to enforce the law and provided penalties for those who refused to obey segregation orders. Homer Plessy, a black passenger who had been punished with a jail sentence and fined for disobeying the act, challenged the conviction as a violation of the 13th Amendment's prohibition against slavery and the 14th Amendment's stricture against denying equal protection of the laws by the states. The Supreme Court dismissed Plessy's claim under the 13th Amendment and ruled that state laws requiring segregation on the basis of race did not violate the Equal Protection Clause of the 14th Amendment so long as facilities were substantially equal. In so holding, the court gave legal sanction to the separate but equal doctrine. Writing for the majority of the court, Justice Brown argued that the constitutionality of this act is attacked upon the ground that it conflicts with both the 13th Amendment of the Constitution abolishing slavery and the 14th Amendment, which prohibits certain restrictive legislation on the part of the states. That it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude except as a punishment for crime, is too clear for argument. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as a chattel, or at least the control of the labor and services of one man for the benefit of another, and the absence of a legal right to the disposal of his own person, property, and services. A statute which implies merely a legal distinction between the white and colored races, a distinction which is founded in the color of the two races, and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of the two races or reestablish a state of involuntary servitude. By the 14th Amendment, the states are forbidden from making or enforcing any law which shall deny to any person within their jurisdiction the equal protection of the laws. The object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality or a commingling of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into conflict do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures in the exercise of their police power. The most common instance of this is connected with the establishment of separate schools for white and colored children, which have been held to be a valid exercise of the legislative power even by courts of states where the political rights of the colored race have been longest and most earnestly enforced. Thus, in his opinion, Justice Brown is stating explicitly what Justice Bradley had intimated in his opinion in the civil rights cases of 1883. There is a difference between political, legal, and civil equality on the one hand versus social equality on the other hand. Justice Brown is emphatically concluding that the 14th Amendment requires the former rather than the latter.